Welcome to Case by Case. Today we are going to go over a couple of new filings that were dropped into the CCS system in Indiana. If you've been following the Delphi appeals process at all, you'll know that there's been a few things filed throughout the last several months. When an appeal of this magnitude especially kicks off, there's always going to be a big delay before the actual appeal is filed. And appellate courts try to keep the case on track by giving them deadlines and holding them to deadlines. But in a case of this magnitude, where the volume of the transcript was 22, or the size of the transcript was 22 volumes, I think it was nearly 5,500 pages. And that's not including a lot of the exhibits that started to trickle in later and the things that we still have missing that never were released. There's also things that the defense have found on their own and they handed it over to the appellate court. So all of that is going to add up as well. Those are interviews that weren't disclosed, or maybe video recordings, anything like that that was not a part of the trial, but it should have been. So what I'm going to do today is I'm going to read through these two new filings and talk about it with you so that you understand a bit about what's going on. Okay, so the first one was, they were both filed together. They were filed on December 1st, 2025 at 3:04 p.m. Now, when it has the stamp up there in the right corner, filed, everything in Indiana is e-filed. So when we file e-filed documents, it's going to timestamp them when they're received by the clerk and by the system. And then, of course, as soon as everything is like it should be, it goes up on the record. So in the Indiana Court of Appeals, cause number 25A CR 00591, Richard Allen versus State of Indiana. This is an appeal from the Carroll Circuit Court. Cause number 08C01-2210-MR-1. MR stands for a murder charge. They have unique case numbers in Indiana. It's pretty helpful when you're looking for something, because if you're looking for a particular type of thing, it might have set letters for it. Belated motion for permission to file oversized appellant's brief. Now, let me just explain this for a moment. Every state has laws on very strict guidelines for appeals. So in New Hampshire, for example, in New Hampshire, the appeal has to be not only a certain length, filed by a certain time, but they also have to use a specific format, including the font, the size of the font, and the spacing. And the reason that states do this is so that it is equally consistent across the board, and you don't have one that's little bitty text and one that's not. It's just very easy for them to understand at an appellate court level what they're looking at and find things easily. So, having worked on quite a number of appellate briefs over the past 20 years, I can tell you that it is a very nuanced business, and the attorneys that do appellate work are not going to be your trial attorneys. Now, your trial attorneys may give everything over to the appellate attorneys, and they may be there to answer questions. But oftentimes, and I've seen this in appellate cases I've helped with, we've not even been able to get a response from the trial attorney. We've had to, go on the record requesting that they communicate with us. And in one case, the only thing we could do was force them to write a written statement, and they submitted a written statement. So It doesn't always happen that way. Most of the time, the defense attorneys are eager to hand things over to the appellate attorney. But keep in mind, appellate attorneys are almost always going to have a hit at the previous attorneys. Okay? They're almost always going to say that the previous attorneys did not do their job when they did X, Y, and Z. So you're always, well, not always, but you're almost always going to see an inadequate counsel or something like that on these appeals. So I bring that out to say that because of that, oftentimes the defense attorneys want to step away from it. They don't really want to be a part of all of this. Now, that doesn't seem to have been the case in this. I've heard Andy Baldwin, who was one of the trial attorneys, say on live recordings on a number of times that he fully expected that they would be laying some of this at him, and that he's happy for them to do so, that whatever it takes to prove that this was not a fair trial, he's okay with. All right, so with all of that being said, and I say that because to understand just how specific appeal briefs have to be, you can understand how you can work 15 hours a day and still not get it completely done. And a lot of people dismiss that, but I'm here to tell you from personal experience, even very straightforward criminal cases that don't involve murder can be very, very, you've got to do your research, you've got to pull your records, you've got to put it all together, and then you've got to write it in the right manner that's persuasive enough to get some attention. So, belated motion for permission to file oversized appellant's brief. The appellant Richard Allen by counsel Mark K. Lehman and Stacy Uliana, pursuant to appellate Rule 44B, respectfully request this court for permission to file an oversized brief. In support of the motion, Allen states following. On November 11, 2024, following a 25-day trial, a jury found Allen guilty of 2 counts of murder. At a sentencing hearing on December 20th, 2024, the court entered an order sentencing Allen to an aggregate term of 130 years. On January 20th, 25, a motion to correct errors was filed. On February 14th, 2025, an order denying the motion to correct errors was filed. A notice of appeal was filed on March 11th. After extensions of time and a remand to supplement the record with missing exhibits, the appellate's brief is due December 10th. Pursuant to Appellate Rule 44E, an appellate's brief cannot exceed 14,000 words. That may sound like a lot. It's not a lot. 14,000 words for a case of this magnitude is not lengthy. Allen respectfully requests permission to file an appellate's brief that does exceed the 14,000 words. Allen's request, at least, I think that's supposed to be Allen requests, at least an additional 10,000 words for the following reasons. A, transcript is over 5,076 words. That's 22 volumes. The documentary exhibits are almost just as long as the 25-day trial at 4,782 words. That's 20 volumes. There are 210 electronic exhibits and medial files. B, to properly summarize the evidence requires a lengthy statement of case and statement of facts. C, counsel has identified at least 10 possible issues for appeal, 9 of which involve federal and Indiana constitutional claims. These claims are broken into 5 different categories. 1, the right to present a defense including alternative explanations of the scene and other suspects and impeachment of the quality of the investigation. That's your third-party suspects. Number 2, the right to present a defense undermining the reliability of Allen's incriminating statements. That's your defense about his mental state, whether or not he was in the right frame of mind, was lucid, or was on medication, or was having some sort of breakdown when he said the words that he said. 3, the constitutionality of those statements while made while Allen was gravely disability, it should say disabled, in prolonged pretrial solitary confinement. That's the issue that goes to why was he in solitude? He hadn't been convicted yet. He was at Westville, and he should have been in a county jail. The constitutionality of the search of Allen's home, that's the issue that goes to that they really didn't have probable cause, and all of the information was not given properly, or there wouldn't have been a search warrant signed. 5, other impactful erroneous evidentiary rulings. Now that's going to be the one that goes towards not allowing this in and not allowing that in, and everything that happened along the way. And it's really good to see this, because so many people out there believe that, well, they convicted him and the prosecution wouldn't just put somebody in prison that didn't do the crimes. Yes, they would. Yes, they would. Yes, they do. I'm not saying it happens across the board, and most prosecutors are good people. But I will say that there's a handful of places where corruption has run amok. And this is one of those places. Everything we look at, there's one more stone that reveals the rot that's growing in this county, in this area. So all of those make up this group of issues for appeal. D, because many of these issues involve analysis of evidence that was proffered but excluded from trial, the record is much larger than just the evidence the jury was allowed to hear. And that's what we just talked about a minute ago. E, counsel is aware of this court's preference that litigants do not argue an excessive number of issues on appeal. F, however, the Indiana Supreme Court has held, quote, if an issue was known and available on direct appeal but not raised, it is procedurally defaulted as a basis for relief in subsequent proceedings. And that's case Williams v. State, 808, NE 2nd, 652, 659, Indiana 2004. There was an extraordinary number of constitutional and evidentiary issues raised by both sides in this case. G, to adequately litigate the issues counsel has identified, they must have a word limit that allows them to cogently present the facts and issues. H, additionally, any federal constitutional claims upon which Allen would seek relief must be raised in state court, or it will be deemed unexhausted and therefore unreviewable should Allen later need to seek federal review of his case pursuant to 28 U.S.C. subsection 2254. Or section 2254. Exhaustion for purposes of 2254B requires that a claimant make a full and fair representation or presentation of his claims in state court proceedings to give the state court an opportunity to resolve federal constitutional claims before those claims are presented to federal courts. And if you think about it, it makes sense. The trial took place at the state level. So we want to give the states every opportunity to fix a wrong. We don't want to always just jump ahead and skip over them and go straight to federal, because if we do that, and there is a remedy at the state level, the state should have the ability to go back in and fix it according to what the appeals court rules. Appellate Rule 44E requires this is number 10, requires the request for an oversized brief to be filed 15 days before the due date of the appellant's brief. Although the appellant's brief is due in 10 days, Allen respectfully requests a variance from the rule Counsel did not know the number of additional words needed until sufficient progress had been made on reviewing the supplemental transcript provided weeks ago and incorporating that evidence into their statement of facts and argument. Although counsel is still in the process of drafting the aforementioned arguments and incorporating exhibits, counsel believes that an additional 10,000 words are needed. 11. The requested 24,000 words is the minimum necessary to provide Allen his constitutional right to effective assistance of counsel in raising the important and constitutional issues in this case. With exhibits, this case is at least 10 times the size of an average murder trial. Whereas, appellant by counsel respectfully requests this court to permit Allen to file an oversized brief to increase the word limit to at least 24,000 words and for all other relief just and proper in the premises. So, that was signed, sealed, given a certificate of service, and went into the e-filing system. Now let's go over and look at the other one that was filed that same day. It wouldn't be hard to guess that it's a motion for an extension. Because if they're going to need to file an oversized brief with 10,000 more words, they're obviously going to ask for additional time to make sure this is done correctly. Motion for final extension of time in which to file appellant's brief. The appellant, Richard Allen, by counsel, respectfully requests this court for permission for a final extension of time in which to file the appellant's brief. In support of the motion, Allen states the following. On November 11th, 2024, following a 25-day trial, a jury found Allen guilty of 2 counts murder. At a sentencing hearing on December 20th, 2024, the court sentenced Allen to an aggregate term of 130 years. On January 20th, 2025, a motion to correct was filed. It was denied on February 14th, and then the notice of appeal was filed March 11th, 2025. A notice of completion of clerk's record was filed on March 14th. Following 2 extensions of time, a notice of completion of transcripts was filed on July 7th, 2025. On October 22nd, 2025, this court ordered the court report to file, it should be court reporter, to file supplemental exhibit volumes, including the exhibits that were attached to Allen's motion for Frank's hearing and motion to correct errors. The court ordered Allen's appellant's brief due 30 days after the clerk filed an amended notice of completion of the supplemental transcript. On November 10th, the clerk filed that amended notice of completion. So counsel for Allen is asking for a final extension of 7 days to complete and file the brief. Despite the exercise of due diligence, undersigned counsel will be unable to complete the brief by the deadline for the following reasons. A. Counsel is still in the process of incorporating the evidence from the supplemental transcript filed on November 10th into appellant's brief. The supplemental transcript was the size of a standard murder trial transcript, including 5 volumes, 1,201 pages, and 7 depositions. In addition, there were many electronic exhibits, including 8 recorded witness interviews lasting about 10 hours. Now, those recorded witness interviews, those are interviews we really want to see, because I believe those are the recorded witness interviews with the Rushville guys, Todd Click and Murphy and Ferenczi, who were really investigating the Ognist angle very deeply. And we are trying to get those. In addition, counsel was unable to help with the review of exhibits and appeal due to her other obligation as lead counsel on an LWOP jury trial, that's a life without parole, that began on November 10th, 2025. That's State v. Jones. The case involved an 18-year-old with intellectual disability who killed a police officer during a high-speed chase. Coordinating experts and out-of-town witnesses and preparing the case took nearly all of counsel's time from October 27th to November 14th, when it concluded with a plea agreement on the 5th day of jury trial. I got to speak to this for a second, because when you have poured your heart and soul into a trial, and you're ready and you stay up the night before and you're ready to walk into court, you're nervous, everything's going on, and then you get into the trial and then you get a plea agreement after you've spent all that time, all that money, it's sort of a bitter-edged sword, you could say, double-edged sword, because yeah, you're happy that something has come to an agreement and it works it out, but you're also frustrated that why couldn't we have done that before trial started? In fact, why couldn't we have done that? We were talking about it way back before I built my trial notebook, before I did everything that I needed to do. Anyway, that being said, C, both counsel have been working diligently on this appeal with 10 to 12-hour days, I have no doubt. But it is so complex and voluminous that an adequate brief cannot reasonably be prepared by the date the brief is due. The transcript is over 5,076 words, 22 volumes, including the new supplemental transcript. The documentary exhibits are almost as long as the 25-day trial at 4,782 words, and that's 20 volumes. Counsel has simultaneously filed for permission to file an oversized brief. Now, we just went through all of that. So counsel needs an additional 7 days to ensure they adequately identified and briefed these issues. Their failure to do so would violate Allen's right to effective assistance of counsel and become an issue in later proceedings. Counsel respectfully submits that an additional 7 days will be sufficient to complete the brief. Allen is currently detained out of state through the Indiana Department of Correction. And then they do their sign, their verification, their certificate of service that it went into the e-system. Okay, so just to wrap up, what could happen from this point is the court could deny it and say, we're not giving you the permission for a larger brief filing, and we're also not giving you 7 days extension, because if you don't have to file that extra, you don't need it. This is a jurisdictional thing, but in the states that I help appellate attorneys with their cases, when we file appeals, most of the time, these things get granted, because the appeals court wants to see more than less. In other words, if it's important to the case, if it bears facts on, the process, because remember something, the appeals process is not about the merits of the case. They are about the procedure and the process, and whether or not the judge, who is the trier of, the jury was the trier of fact, but the judge who was over all the evidence and the procedures and the process, whether the judge made incorrect rulings for any reason. It could be that she didn't understand the law. It could be that she didn't like the defendant. She didn't like the attorney. She woke up on the wrong side of the bed. It could be that she just didn't realize until later on, and by then the damage was done. There are a lot of reasons why the process can break down during trial and things not get accepted into trial. Third-party evidence is such a big thing, and I was talking to some of the appellate attorneys that I know in different areas, and we were all shocked that the third-party defense was not seen as a close enough nexus to be warranted. Because typically you want to give your defendant any valid opportunity to say, it's not me. I wasn't there. It was some other guy. And, you know, we call it the Saudi defense, which is some other dude did it or someone else did it. That's just how people say it. But typically, a trial attorney will let that come in unless it's just so far removed that you can't see it. Now, I don't practice. I help other attorneys behind the scenes because I have a law degree and I have that experience, but I've never tried a murder case. And I can tell you that I could not see how those things were not related. I mean, I followed everything when the transcripts came in. I read every bit of them. I made notes. I went back. I talked to other attorneys that I know. And it just doesn't seem plausible that they weren't allowed to present third party. And there were some other things too that, you know, I felt like they were wrong. But I wasn't in the courtroom either. So I had to rely on, you know, the Matas and Andrea Burkhart and Lawyer Lee and so many others. And one thing I do want to point out about that is I think it's interesting that all these people that were there all had one story, the same thing. And the one group, the murder sheets, are the other ones that had the opposite. Now, the prosecutors sort of feel like he's guilty, but they weren't there in the court either. So I'm talking about of the people that were the professionals that were sitting every day in the court. Murder sheets, one of them is an attorney and he's licensed. I don't know if he practices, but he would have known a little bit about the law and what to look for, even if he had not done this type of thing. So it's interesting to me that that was the only attorney that was there that I know of that came away going, yep, they got it right. And all these other attorneys, some defense and some not, came away saying, what happened here? How did they get it so wrong? So I bring all that up to say that I think that there's a good chance, this is just my opinion, a good chance that some of these issues are going to get the appeals court's attention. And I'm hoping that that's what happens. So we will see. What we're going to do is the next time any motions get filed, I will record those and read them to you and bring them onto the channel so that we can discuss them together. And then if you have questions, you can either write it in the comments, but preferably if you'll go to our case-by-case discussion group. It is much more than Delphi, but there are a lot of discussions related to Delphi. If you'll go in there, you can start a discussion related to any of these that we've done. So I hope that this helps you understand it. And this is case by case. And I hope that you have a